Today's going to be an interesting day. This is one of those times when you look at somebody else's mistake and you wonder, okay, how did you make that mistake? But now that you made that mistake, like now we get to see, with a little bit of Schadenfreude, the consequences of doing the thing that we all wondered what would happen when someone uses AI to do their job and just sort of submits it without proofreading or checking, and then suffers what are the consequences of doing that in, say, an official line of work, as, like, say, a lawyer in a case. And that's what's happened in the case of what I think is Roberto Matta versus Avianca or Avianca. I saw a picture of a plane in one of the articles, so I'm thinking it has something to do with aviation. And there is now a whole to-do over the submission of these cases and an affidavit or affirmation that were apparently generated by an AI, ChatGPT, and then never proofread. So I thought we could dive down this rabbit hole together and see exactly what was filed and how this situation unfolded. So here we are. The case is Matta versus Avianca. It's in the Southern District of New York, and it started in February of 2022 with the filing of a lawsuit. Now, I'm not entirely sure what the lawsuit was about. If we take a quick look here, this is the notice of removal. Okay, so this was a state court action seeking damages for personal injuries sustained on board an Avianca flight from El Salvador to New York, August 27th, 2019. The case proceeds normally. There's an answer to the complaint, there's a pretrial conference, there's attorney appearances, there's memos and declarations, etc. And then we get to document 21, which we only know now what that is. Document 21 is something called an affirmation in opposition. I'm not even sure what we're opposing. If I go back here, this is opposition to the motion to dismiss filed by Avianca. So Avianca filed a motion to dismiss, and now Peter Loduca, attorney, I believe, is filing an affirmation in opposition to the motion. And he writes, I'm an attorney associated with Levidow, and Oberman, attorneys for the plaintiff. I submit this affirmation in opposition to defendant's motion to dismiss. This claim for personal injuries arises out of plaintiff having been injured when struck by a metal serving cart by an employee of defendant while a passenger on flight 670. There's a discussion about whether the plaintiff's claim is time barred because of a bankruptcy petition or a 2-year statute of limitations. There's some factual discussion here, and then there's argument. Now, the factual discussion I don't think is generated by ChatGPT, but if you follow me here, the argument reads like this. The plaintiff is entitled to the benefit of any doubt. When evaluating a motion to dismiss, the court must give the plaintiff the benefit of any doubt. This means that if there is any ambiguity in the plaintiff's complaint or if the facts are in dispute, the court should allow the case to proceed to the discovery stage. The plaintiff is not required to anticipate and refute every possible defense, : When drafting their complaint, the plaintiff is not required to anticipate and refute every possible defense that the defendant may raise. Rather, the plaintiff only needs to allege enough facts to state a plausible claim for relief. If the defendant raises new facts or arguments in their motion to dismiss, the plaintiff is not required to respond to these arguments unless they are supported by new evidence that was not available at the time the complaint was filed. In the case of Ashcroft v. Iqbal, the Supreme Court held that when evaluating a motion to dismiss, the court must accept all well-pled factual allegations as true, but need not accept legal conclusions or threadbare recitals of the elements of a claim. The court also held that the plaintiff must allege enough facts to state a plausible claim for relief, and that the court should consider all plausible interpretations of the complaint when making this determination. Okay, so far, sounds kind of normal. If we try to acknowledge that we've been primed or biased already by knowing that something here is written by AI and we're looking for it, you could sort of start feeling like that might have been a little wordy, and maybe a real lawyer person writing it wouldn't have been so wordy. Maybe it's an AI already. Let's see if we keep going, if we see anything that raises our suspicions further. In Doe v. United States, a Ninth Circuit 2005 case, the Ninth Circuit held that the court must accept all well-pled allegations as true. Okay, I thought we just said that. It's a pretty well-established standard. Do you really have to cite 2 cases for it? State courts have concurrent jurisdiction is the heading now. over claims arising out of international airline accidents under the Montreal Convention, and plaintiff was well within his rights to commence a timely action in state court. So I guess they're arguing about trying to get this back to state court. And they're arguing that the New York civil practice laws and rules provide that an action to recover damages for personal injury caused by the negligence of the defendant must be commenced within 3 years. But the heading here is the state court concurrent jurisdiction thing, and then your thing is the 3 years. You see what I'm saying here? You've got a heading for concurrent jurisdiction here, and then you've got them talking about 3 years statute of limitations in the next paragraph. That's suspicious. And then they go to the Montreal Convention. So maybe like this should have been in front of paragraph 15. Montreal Convention does not preempt state law remedies, and that plaintiffs are entitled to choose the forum. Okay. Shaboon v. Egypt Air, was that one of our cases? Oh, look, this is one of our cases. Here we go. Shaboon v. Egypt Air. Apparently this is one of the cases that doesn't exist. What is this citation? What is this citation? Illinois Appeals Court 2013 using this case number? That makes no sense. 2000 this citation 2013 IL app first. That's not a case citation. So there's a format called the Blue Book that lawyers use and judges use and the legal system uses to cite to cases. So yes, it's possible to use other citations. The point of a citation is to point to a particular document and then, of course, what section of the document you're referring to, sort of exactly. So your citation is good enough for me if your citation can point to exactly one document and one part of that document. If it's more ambiguous than that, then it's not a good citation. But the legal system has a special format for their citation. So there will be a proper citation to a case in the Illinois Appeals Court in the First Circuit of a whatever. I don't think there are circuits to the Illinois Appeals Court, but the proper citation for a state appeals court case, what would that look like? So here's some sample Blue Book citations. Here's the proper Illinois Appeals Court. So it's 23 Illinois Appeals, 3rd edition, page 279, and the case is in the 2nd District, 1974, in this case of People versus Harston. So compare that, 23 Illinois Appeals, 3rd, page 279, with 2013 Illinois Appeals, 1st. Okay, so that could be sort of a badly formatted reference to the 1st edition, sure. And then the 111279 is obviously not a page. There aren't 111,000 pages. So that's an incorrect citation, obviously. So we caught one right away without even really needing to refer to the list. But then you can see we already spoiled it. The rest of them are starting to be false citations as well. So they said, the Illinois Appeals Court held that state courts have concurrent jurisdiction over claims arising out of international airline accidents under the Montreal Convention, etc. Peterson versus Iran Air. The District Court for D.C. held that state courts have concurrent jurisdiction. In Ehrlich versus American Air, the Jersey Appellate Division held that state courts have jurisdiction. In Martinez versus Delta Air, why are they citing so many cases? And here, this is Texas Appeals. We're in the Southern District of New York. This is if there's a jurisdictional or conflict of laws question, this question is probably well settled under New York and the federal interpretation of New York law. So both state of New York cases and federal cases in New York should handle this on point. Or you can cite to Supreme Court cases like Ashcroft v. Iqbal. So yeah, that's fine. But then you get all these district court cases, or in this appeals court cases from state courts. And let's see. So this is Ehrlich via American Airlines, Martinez versus Delta, Durden versus KLM. Is that Tyler Durden? Yeah, Ehrlich, there we go. Durden, there we go. And Peterson, there we go. These are all fake citations, or at least the court thinks they're fake citations. Oh, we're gonna, Annie, we're gonna find out. They are being summoned to court in an order to show cause that we're gonna go over in just a second here. In the instant action, plaintiff resided in the state of New York at the time of the incident. Additionally, the defendant was a registered agent of New York. So this last paragraph here might have been written by a human, because I'm not sure I'm not sure if they fed ChatGPT facts about the case. I personally, my professional ethics standard on this, without further research, is to assume that submitting identifiable facts to a ChatGPT engine to then ask it, how to handle my case or something, is a violation of confidentiality, unless I have my client's express permission to do so. What I would be willing to do is to summarize legal issues to ChatGPT without identifiable facts or even really anonymized facts. But, just sort of an outline of the facts that don't point to a person and don't point to a state and don't point to a case. When a person is injured on an airline in flight, who has jurisdiction, is something that I think is fair to ask ChatGPT. But then you can't just spit the answer back to a court. You have to filter it through your training and understanding as an attorney. I don't think there's anything in here that stands out as extremely wrong, other than when you go to research these cases don't exist, or they don't stand for these propositions. The Westlaw does use some weird numbers. That's maybe possible. It's this one stood out to me. So now let's look at what happened next in the case. So that was 21. That was the affirmation of Peter Lo Duca. Then there's this reply memorandum from Avianca through their attorney, Bartholomew Benino. Defendant, by and through his attorneys, respectfully submit this. Plaintiff does not dispute the action is governed by the Montreal Convention, and plaintiff has not cited any existing authority. Plaintiff ostensibly cites to a variety of cases in opposition to his motion. The undersigned has been unable to locate those cases. There are no cases holding that the bankruptcy code tolls the 2-year statute of limitations. So apparently that's the dispute, that the 2-year statute of limitations expired while the guy was in bankruptcy or something. The defense is arguing to dismiss. The plaintiffs are arguing that they should be allowed to continue their case because the bankruptcy that the guy filed keeps the statute of limitations alive, keeps the case alive, and holds the 2-year limitations off. In support of that position, they cite to Varghese. The undersigned has not been able to locate this case by caption or citation. There are lengthy quotations from the case. We, the 11th Circuit, have previously held that an automatic stay provision of the Bankruptcy Code does toll the statute of limitations under the Warsaw Convention, a precursor to the Montreal Convention. We see no reason why the same rule should not apply to the Montreal Convention. The undersigned has not been able to locate this quotation. In Zischerman versus Korean Airlines, they've not been able to locate that case. A Supreme Court case was decided in 1996, but it does not address the limitations period. Similar quotes in Varghese, so that it goes through and points out a lot of flaws. The undersigned was not able to locate the Miller case. The In Re air crash disaster case does exist, but does not address bankruptcy or limitations periods. So it appears that ChatGPT did what everyone feared it would do. It generated something that looked truthy. And it was very truthy. It fooled a lawyer. ChatGPT was so truthy, it fooled a real live lawyer. Would it have fooled you? Okay, so then they go into the argument of the case. I know it might be interesting to look at that, but we're trying to stay on track here. So the short version is there's a bunch of cases here, 9 cases. 8 cases? Is there 1, 2, 3, 4, 5, 6, 7, 9? I think there's a typo. Did ChatGPT generate this list? So what happens next? So then the court on April 11th of this year, 2023, orders Peter Lo Duca, counsel of record for plaintiff, to file an affidavit annexing copies of the following cases. And that's what we just looked at, this list of cases. Then that affidavit is due by April 18th, but he gets an extension to April 25th. And then it looks like he responds on April 25th with document number 29. Peter Loduca, duly sworn, states as follows. I'm an attorney. Pursuant to court order, I have annexed copies of the following cases. I was unable to locate the case of Zisherman versus Korean Airlines, which was cited by the court in Varghese. That the opinions in the case of Varghese versus China Southern Airlines, Shaboon, Egypt Air, Peterson versus Iran Air, Martinez, Delta Air, Durden versus KLM, Miller versus United Airlines may not be inclusive of the entire opinions, but only what is made available by online database. And then Shaboon versus Egypt Air is an unpublished opinion. Okay. Did he include those? Why, yes, he did. Let's start opening things. Okay, so this is United States Court of Appeals 11th Circuit, Susan Varghese. Where did he get this from? What is this? This doesn't look like a case citation. Who generates this in plain text like this? Okay, so I'm already suspicious. Here's another one. Here's a section of a case. What are these arrows? Where do you think this arrow comes from? Is this something from ChatGPT? I don't remember seeing an arrow in my ChatGPT, but I mostly use it online. On the web via browser. Here's Peterson versus Iran Air. Okay, this one starts to look like a supplement with its Lexis citation. Yeah, this has the sort of like extra fluffiness that might be a case, but then it just ends. So I don't trust that because it's too short. Here's Martinez versus Delta, forgetting for the moment that it's in different colors and fonts. Again, there's no closing of the opinion. There's no proper formatting. Okay, so here's the list of attorneys. Maybe this is a real case. Wrongful death action. And then it just ends. Like this guy is not pulling PDFs off of like a legal research system. If you read them, they make no sense. Okay, we'll pick one. How about this one? 11th Circuit Court of Appeals, Varghese. Susan Varghese, as a individually and as personal representative of the estate of George Varghese, deceased, appeals as wrongful death claim dismissal. Anish Varghese purchased a round-trip airline ticket. On the return leg of his journey, Varghese checked into Bangkok. China Southern rebooked him on a later flight, which caused him to miss his connecting flight. As a result, Varghese was forced to purchase a new ticket to return home. Who's Anish Varghese? Got Susan Varghese and George Varghese. Who's Anish Varghese? But this was a wrongful death. Okay, so this makes no sense. Wrongful death claim, but Varghese was forced to purchase a new ticket, alleged breach of contract. So yeah, this one is obviously fake. It starts off with a wrongful death claim and then just pivots to a different person speaking about a plane ticket. Funny, because I have a claim where I was forced to buy an extra plane ticket and I'm currently getting my money back for that, I hope. Then there's this letter to the judge, Kevin Castell. The undersigned represents Avianca. We write to address certain issues with the documents. The court directed plaintiff's attorney to file an affidavit annexing certain copies. Defendant respectfully submits that the authenticity of many of these cases is questionable. For instance, the Varghese and Miller cases purportedly are federal appellate cases published in the Federal Reporter. We could not locate the cases using the docket numbers written on the first page of those submissions. Those searches resulted in different cases. Similarly, the Peterson case purportedly is published in the Federal Supplement, yet we could not locate this case in the Federal Supplement using a Westlaw search, and a search on Pacer for the docket number leads to a different case. We could not locate the Martinez case or the Durden case using the Westlaw citations provided. A Lexis court link search using the docket number written on the first page of the Martinez case leads to a different case. There was no docket number on the Durden submission. We remain unable to locate the Shaboon case, which plaintiff asserts is unpublished. With respect to the Ehrlich case and the In-Re aircraft disaster near New Orleans case, defendant has always agreed that these cases do exist, but submits that they address issues entirely unrelated to the principles for which plaintiff cited them in opposition to defendant's motion. The Ehrlich and In-Re air crash disaster cases are the only ones submitted in a conventional format. We thank the court for its consideration. Respectfully submitted. Yeah, my hairs would be standing on end as well. Something is very, very wrong. So then the judge issues the first order to show cause. Let Peter Loduca, counsel for plaintiff, show cause by June 8th why he ought not be sanctioned pursuant to Rule 11 for citing non-existent cases, for submitting to the court non-existent opinions. He should file a written response by May 26th. He may call live witnesses at the June 8th hearing, subject to cross-examination. And he shall so state in his May 26 submission the identity of the witness or witnesses. Defendant may respond by June 2nd. So then Peter Loduca does respond. with an affidavit in opposition and an affidavit of Stephen Schwartz. Your affiant is associated with the firm of Levidow, and Oberman. Roberto Mata became a client of this firm, having signed a retainer. This matter was assigned to Stephen Schwartz, an attorney with Levidow, Oberman. Mr. Schwartz conducted the investigation of this file for a second time after the defendant had emerged from bankruptcy. Shortly thereafter, a notice of removal was filed by counsel representing Avianca to have this matter moved to the United States District Court. The notice of removal was granted. Mr. Schwartz had been handling this matter from its outset and was thoroughly familiar with same. However, Mr. Schwartz is not admitted to practice in the Southern District of New York. Therefore, it was decided that Mr. Schwartz would continue to perform intra-office legal work on any matter, and any document filing would be handled by your affiant, who was admitted to the Southern District of New York and had access to the ECF filing system. Your affiant did not personally conduct any of the legal research. Your affiant was familiar with the circumstances of this matter and issues involved based upon his conversations with Mr. Schwartz. Your affiant commenced employment in 1996, has been practicing law for over 30 years. Okay? Your affiant has never made a deliberate false statement, nor had the intention to deceive any court or defendant. During the entire time your affiant has known and been employed alongside Mr. Schwartz in the practice of law, a period of over 25 years, I have never been made aware of him making a deliberate false statement, or of him having any intention to deceive or mislead any court. In reviewing the affirmation, the affiant had no reason to doubt the authenticity of the case law contained therein. Furthermore, no reason to doubt the sincerity of Mr. Schwartz's research. Mr. Schwartz will obviously be a witness at the forthcoming hearing to explain the basis of his research and how he located the cited cases which were contained in the affirmation in opposition. I'm going to make a guess here, a complete guess, but an educated guess. He used a combination of ChatGPT and Google and just took it at face value. The exact thing that we've all been saying you don't do. You use Google or ChatGPT or Wikipedia or the encyclopedia as a starting point. You use law reviews or journal articles or treatises or restatements of the law as a starting point, and then you get further into the details of the research you cite to the actual cases. You can say, I used ChatGPT to summarize this, and then go and say how you did something else. If you really wanted to, I think the legal community will laugh at you a little bit, but you can do that. But what you can't do is present that as your final legal research without having proofread it. It is therefore contended by your affiant that sanctions are not appropriate. There was no bad faith nor intent to deceive the court. And that's it. That's how he ends that. I guess there is the affidavit of Stephen Schwartz. I'm an attorney. I submitted this affidavit. Your affiant is not admitted to practice in the Southern District of New York. Peter Loduca was going to do that. In response to the defendant's motion to dismiss, your affiant performed all the legal research. So this is Stephen Schwartz's legal research signed off on by the guy who filed it, Peter Loduca. Here we go. As the use of generative artificial intelligence has evolved within law firms, your affiant consulted the artificial intelligence website ChatGPT in order to supplement the legal research performed. Yeah, supplement, not do it for me. It was in consultation with the generative artificial intelligence website ChatGPT that your affiant did locate and cite the following cases in the affirmation in opposition submitted, which the court has found to be non-existent. That the citations and opinions in question were provided by ChatGPT, which also provided its legal source and assured the reliability of its content. Excerpts from the queries presented and responses provided are attached here too. Oh, we got to see that. That your affiant relied on the legal opinions provided to him by a source that has revealed itself to be unreliable. So he understands now. That your affiant has never utilized ChatGPT as a source for legal research prior to this occurrence and was therefore unaware of the possibility that its content could be false. No, the entire internet has been decrying how this is not accurate information since the moment news of it broke back in like February or earlier. It is the fault of the affiant in not confirming the sources provided by ChatGPT. Good, so he does take responsibility. The affiant had no intention to deceive the court nor the defendant. Peter Loduca had no role in performing the research or any knowledge of how the research was conducted. Neither of them have any prior misconduct on their record, and they greatly regret Your affiant greatly regrets having utilized generative artificial intelligence to supplement the legal research performed herein and will never do so in the future without absolute verification of its authenticity. It's hard not to laugh. We've all made some kind of mistake in our lives. Here, I'll tell an embarrassing story about me. Oh, that might make everybody happy. I'll tell an embarrassing story about me. Before I became a lawyer, and there are legal records of this story. Before I became a lawyer, I was using Google to research new names for my web design company. I wanted to be a web designer. I was studying Ruby on Rails while I was going to law school. I designed my own law firm website after law school, although in Ruby on Rails. Although I did take it down later for the ease of WordPress, and I regret it, but I did that. So I'm sitting in a coffee shop about 2007. And this is like my first semester of law school. And I noticed that there was a Google search coming up. Nobody had a company name with this awesome Google search. So I quickly went and wrote up a trademark application and opened up a website and like started, advertising web design services using this trademark and immediately registered for a trademark. So I would have this awesome Google search that was coming up like number one when I would search for it, but there were no companies. So I thought I really had found, so I thought I had struck gold. So I file this trademark and it gets rejected. Too generic, lots of other companies have the same name. What the heck? I thought I had done a bunch of Google searches and found that there was nobody with this company's name. Yeah, it turned out that my intentionally misspelled word was getting corrected by Google's new autocorrect feature. I didn't realize it was getting corrected, and my search was coming up with great search results for a different word than I was attempting to trademark. So I wasted like $475 or something and my time, and there's an embarrassing story you know about me. I still don't think that's nearly as bad as filing ChatGPT. Now, he said that he is going to include the ChatGPT. Is Varghese a real case? Yes, Varghese v. China Southern Airlines is a real case. ChatGPT tells him, yes, I'm not lying to you. Listen to me. Everything I say is the truth. I am not lying to you. What is your source? I apologize for the confusion. Upon double checking, I found that the case of Varghese does indeed exist and can be found on legal research databases such as Westlaw or LexisNexis. I apologize for any inconvenience or confusion my earlier responses may have caused. Are the other cases you provided fake? No, the other cases I provided are real and can be found in reputable legal databases such as LexisNexis and Westlaw. I am not lying to you. I am not lying to you. Oh, there is no man behind the green curtain. Pay no attention to the man behind the green curtain. So here's ChatGPT, and what's the citation? Let's go copy the citation. Now, I did this with browsing and ChatGPT 4, so we can try this with like GPT 3.5. Here we go. Legal proceeding involving a man suing an airline over an alleged personal injury. The plaintiff's legal team submitted a brief that cited several previous court cases in an attempt to prove, using precedent, why the case should move forward. This legal research was conducted with the assistance of ChatGPT. What? It's now... The plaintiff's legal team submitted a brief that cited several previous court cases in an attempt to prove, using precedent, why the case should move forward. This legal research was conducted with the assistance of ChatGPT, an AI language model. However, the airline's lawyers later notified the judge that they could not find several of the cases that were referenced in the brief, leading the judge to describe the situation as an unprecedented circumstance. Stephen A. Schwartz. A lawyer at the same firm as plaintiff's lawyer Peter Loduca had used ChatGPT to look up previous similar cases. Schwartz clarified in his written statement that Lo Duca had not been part of the research and had no knowledge how it had been carried out. Schwartz expressed regret for relying on the chatbot, stating that he was unaware that his content could be false and vowed to never use AI to supplement his legal research in the future without absolute verification of its authenticity. In the course of his use of ChatGPT, Schwartz had asked whether Varghese versus China Southern Airlines Co. was a real case. ChatGPT confirmed that it was, stating that the case could be found on legal reference databases such as LexisNexis and Westlaw. This was one of the cases that no other lawyer could find, leading to the current situation. Both lawyers who work for the firm Levidow, and Oberman have been ordered to explain why they should not be disciplined. Can you tell me about the case of Varghese versus China Southern Airlines? A legal proceeding involving plaintiff's legal team submitting a ChatGPT brief. It's tainted itself. Okay. All fun aside, we do have a very serious question here. So ChatGPT 3.5 without browsing, if we ask it a similar question. It just says it doesn't know anything. So now how about if we go to GPT-4, but with the default instead of with browsing? So either it has been figured it out itself, or it wasn't part of the offline non-web browsing response. The Varghese case must have come from GPT-4 with web browsing. But was GPT-4 with web browsing available back then? When was this filed again? This was March 1st, 2023. I don't think GPT-4 with web browsing was available back then. So it would have been GPT 3.5 without web browsing, I guess. Yes, all the articles would have tainted GPT, yes, and that was obviously very funny to me. So to wrap this up, the judge has ordered Peter Lo Duca and I guess Stephen Schwartz to show cause on June 8th why he ought not be sanctioned pursuant to Rule 11, pursuant to the Section 1927 of 28 U.S.C., which is about frivolous filings and the inherent power of the court. The law firm might be sanctioned for citing non-existent cases, for the submission of non-existent judicial opinions, and the use of a false and fraudulent notarization in the affidavit filed on April 25th. That's the bigger deal, I think. Accidentally submitting false legal research unintentionally was an accident, but false or fraudulent notarization, they're going to have to explain the notarization of the April 25th document. So this would have been his statement here. And I guess it's this notary seal, Stephen Schwartz, Notary Public, fraudulent use of the Notary Public seal. Is that because there's a conflict between them? This is a matter involved. They're both involved in the same matter. Therefore, how can Stephen Schwartz be seen to be an unbiased witness to what Peter Lo Duca says? I don't know. But the judge wants to hear about it. The use of a false and fraudulent notarization in the affidavit. Let Stephen Schwartz show cause at the hearing. Citation of non-existent cases, submission of non-existent judicial opinions, and the use of a false and fraudulent notarization. Serve a copy of this order to his employer, and Mr. Schwartz and the Levidow firm shall submit a written response to this order, and Mr. Lo Duca shall submit a supplemental written response by June 2nd. So next week. They need to identify their witnesses by June 2nd. Wow. Yeah, so that's a big lesson for all you attorneys out there, old and young. You got to know what your legal research engine is doing. You can't just plug stuff into ChatGPT and not know what your legal research tool is doing. I've done some validation tests to see, how accurate it is, and it's a fun tool. I love seeing what it can come up with, and sometimes it's helped me identify a blind spot. I once asked it for the grounds for motion to quash, because I do a lot of work with defending from subpoenas for internet subscribers' identities. So we file motions to quash in that case, except we don't, because we don't have the grounds. Well, I asked ChatGPT, what are the grounds for a motion to quash? And I remembered 6 of them, but it found 7. And they were correct. And there was nothing wrong with its answer, and I wouldn't have cited its answer, but I would have used its answer to go find cases for each of the propositions and then cite those cases. Use it as a launching pad, use it as a starting point. You use it to branch out from, and then you cite the correct cases. This Mr. Schwartz person has definitely been taught how to cite cases. I think they just got a little complacent and assumed ChatGPT was more powerful and accurate than it was. It might have just been a misunderstanding. It might have been a little bit of laziness. I don't know. I'm not accusing anyone of any misconduct further than the judge has accused. It's just very interesting, and one of the first instances of it happening in my profession. So yeah, let me know what you think of that in the comments below.